I'm still reading out of section 11. I'm in section F, where we're crediting consumers for substitute check problems, claims that is, under Reg CC. I'm on page 491, and I got cut off at some point under the reversal of the recrediting. A bank may reverse a recredit that is made to a consumer account if the bank determines that the consumer's claim was not valid and the bank notifies the consumer of the reversal. Recredit pending investigation, let me read that first actually, is where I dropped off. If a bank has not taken an action to resolve a claim by the end of the 10th business day after the banking day on which the bank received the claim, the bank must recredit the account for the amount of the consumer's loss up to the lesser of $2,500 or the amount of the substitute check plus interest by the end of that business day. The bank must credit the consumer's account for the remaining amount of the loss plus interest no later than the end of the 45th day. Okay, now the availability of recredit. Section 9 under F. Next day availability. A bank must make any amount that it recredits to a consumer account available for withdrawal no later than the start of the business day after the banking day on which the bank provides the recredit. Safeguard exceptions. A bank may delay the availability of a recredited amount until the earlier of the following two dates. I. The start of the business day after the banking day on which the bank determines the consumer's claim is valid, or 2. The 45th day after the banking day on which the bank received the oral or written claim, provided A. The consumer submits the claim during the 30 calendar day period beginning on the day on which the consumer's account was established. There's probably a B here. Which is a requirement for making this recredit available on the 45th day after the banking day that the claim was received. It provided, without regard to the charge that gave rise to the recredit claim, the balance in the consumer's account was negative on 6 or more business days during the last 6-month time period, and the bank has reasonable cause to believe that the claim is fraudulent based on the facts that would cause a well-grounded belief in the mind of a reasonable person that the claim is fraudulent. Now, there's a section here out of nowhere about overdraft fees. A bank that delays availability may not impose an overdraft fee with respect to drafts drawn on recredited funds until the 5th calendar day after the day the notice was sent. That's actually important. Required notices. Notice of the bank. Notice of recredit. Banks must send a notice of recredit no later than the business day after the banking day on which the bank recredits the consumer's account. The content of the notice is the amount of the recredit and the date on which the recredited funds will be available for withdrawal. Notice that consumer's claim is not valid, covered here. I, if the bank determines that a substitute check for which a consumer makes a claim was in fact properly charged to the account, or that the warranty claim is not valid, the bank shall send a notice to the consumer no later than the business day after the banking day on which the bank makes that determination. The notice must include the original check or copy, a demonstration that the substitute check was properly charged or that the consumer's warranty claim is not valid, any information or documents on which the bank relied in making its determination, or a statement that the consumer may request copies of such information. A notice must The notice of reversal of recredit requires a bank which reverses an amount it previously recredited must send the notice to the consumer no later than the business day after the banking day on which the bank made the reversal. This notice must include the amount of the reversal and the date the reversal was made. Expedited recredit for banks. Circumstances giving rise to a claim. A bank that has an indemnity claim with respect to a substitute check may make an expedited recredit claim against an indemnifying bank if A, B, and C are occurring. And A, the claimant bank has received a claim for expedited recredit from the consumer, or would have been subject to such a claim if the consumer account had been charged for the substitute check. B, the claimant bank is obligated to provide an expedited recredit, and C, the production of the original check or a copy is necessary to determine the validity of the charge to the consumer account or the validity of any warranty claim connected with such substitute check. Validity, no. Check. Period. No period? Right. Procedures for making claims. A claimant bank must send its claim to the indemnifying bank subject to the timing, content, and form requirement of the regulation. So timing is A. The claimant bank must submit its claims that the indemnifying bank receives the claim by the end of the 120th calendar day after the date of the transaction that gave rise to the claim. B. Content of claim. Claim must include a description of the consumer's claim related to the substitute check that includes why the bank believes that the substitute check may not be properly charged to the consumer's account, a statement that the claimant bank is obligated to recredit a consumer account or otherwise has suffered a loss, the reason, 3, why production of the original check or a sufficient copy is necessary to determine the validity of the charge to the consumer account, and 4th, sufficient information to allow the indemnifying bank to identify the substitute check and investigate the claim. Requirements relating to copies of substitute checks. If the information submitted by a claimant bank includes a copy of any substitute check, the claimant bank must take reasonable steps to ensure that the copy cannot be mistaken for the legal equivalent of the check or sent for forward collection or return. 4. Form and submission of claims. The indemnifying bank may require the claimant bank to submit the information in writing, including a copy of the paper or electronic claim submitted by the consumer. If the bank requires a written submission, it A. may permit the claimant to submit a claim. The bank must electronically, may permit the claimant to submit the written claim electronically, must inform the claimant bank of the requirement of a written claim, and last, must compute the 10-day period for acting on the claim from the date that the bank receives a written claim. And this is all for substitute check claims, which I think is probably going to mean that the bank of first deposit, no, the payer bank has paid a substitute check that is not legitimate and is seeking a recredit, or the paying bank has paid twice because the substitute check has been presented twice and is claiming or is requesting a recredit. Those are the circumstances under which this bank, the paying bank called the claimant bank, is asking the indemnifying bank, which is probably the bank of first deposit, or the Fed, in communicating to the bank of first deposit that, or this is my interpretation from experience, is that that's what this is about. Action on claim. Within 10 business days after receiving a claim, the bank must recredit the bank for the amount of the claim up to the amount of the substitute check. This is just substitute checks. Provide to the claimant bank the original check or a copy, and provide information to the claimant bank regarding why the indemnifying bank is not obligated to take action on the claim. Let me also add that sometimes when you're requesting recredit for your bank, it's probably not being done in a timely fashion. So this isn't a day later, this isn't 2 days later, this could be 30 or more days later, which is why they're giving you 10 days, like snail mail rules here. Providing a recredit does not absolve the indemnifying bank from liability for claims brought under any other law or from additional damages. Indemnifying bank's right to a refund. If a claimant bank reverses a recredit it previously made to a consumer account or otherwise receives reimbursement for a substitute check, the bank shall provide a refund promptly to any indemnifying bank that previously advanced the funds to the claimant bank. Meaning that if you make this request for recredit and then the funds are credited to that account, then the bank then has to reverse their recredit because it's been resolved in another way. Because the customer's account can sometimes be recredited by the merchant or by the other party, and in which case the bank's going to be out of balance because the credit's going to be in the customer's account as well as a credit being received from the indemnifying bank. So we are not trying to be duly compensated. Since we're actually coming to an end to this section, let me finish. Liability. General. With exceptions, any person that breaches a warranty or fails to comply with any requirement of this regulation will be liable for an amount equal to A, the amount of loss suffered by the person as a result of the breach or failure up to the amount of the substitute check, and B, interest and expenses related to the substitute check. Now, 2 under liability is about offset of recredits. The amount of damages a person receives will be reduced by any amount recredited. 3, comparative negligence, section under liability. If a person incurs damages that resulted in whole or in part from that person's negligence or failure to act in good faith, the amount of damages due to that person will be reduced in proportion to the amount of negligence or bad faith attributable to that person. Timing. Any delay by a bank beyond the time limits is excused if the delay is caused by an interruption in communication or computer facilities, suspension of payments by another bank, war, emergency conditions, or failure of equipment or other circumstances beyond the control of the bank, provided the bank uses such diligence as the circumstances require. And limitations. Claims must be brought in a U.S. District Court within 1 year of the date on which the person's cause of action accrues. That's great. That means there's 1 year statutory deadline, statute of limitations. Notice of claims. Unless a person gives notice of claim to the warranting or indemnifying bank within 30 days after the person has reason to know of both the claim and the identity of the warranting or indemnifying bank, the warranting or indemnifying bank will be discharged from liability in any action to enforce the claim. Consumer awareness is now the last section before the fear of penalties.